Hello, this is Moosa Qureshi again. I'm again with Chris Day, and today we're going to discuss Health Education England. So Chris, I understand your case is that Health Education England has argued 54,000 doctors out of whistleblowing protection. Could you just explain a little bit how this happened?
Well, the story started, ironically, a few weeks after publication of the Francis report that looked into the failings at mid-staff and recommended all kinds of culture changes in the NHS, leading to a much more transparent NHS. So you can imagine my surprise when Health Education England's approach to my case to defend it was to argue the entire junior medical profession below consultant grade out of statutory whistleblowing protection, and that meant my case couldn't be heard.
So let's get this clear. So yeah, the timing is quite interesting, isn't it? Because we do have this very expensive Francis report, which was into the mid-staffs inquiry. That's published at great expense to taxpayers. We now have an organisation called Health Education England, which is denying any sort of liability for any effect it may have had on your career, saying it's not liable under whistleblowing legislation, and again at great expense to taxpayers. So it almost seems that it's a bit strange, isn't it? It depends. Is the government in favour of whistleblowers, or is it opposed to whistleblowers?
Well, I think that's a really good point you make. I mean, they've got to decide whether they want to crush the whistleblower or pay loads of money to enable them to speak up. But it's very expensive to decide to do both. So there's little justification, I think, of paying Sir Robert Francis QC to do a big report into why people don't speak up in the NHS and then argue 54,000 junior doctors out of whistleblowing protection. I think it's crazy, isn't it?
Yeah, it's very crazy. I mean, I've spent some time reading through quite large sections of the Francis report. It's got 3 volumes. The first volume's about 700 pages. But whistleblowing was really important in that report, going back years and years, about 10 years before the actual scandal broke. You know, there were whistleblowers basically saying things are going wrong at mid-staffs and people ignoring them. And it does seem that we haven't learned any lessons from this. I'm particularly actually very surprised when I was going through this report, on page 1338 of the Francis report, it actually gives a quote from Professor Ian Cumming, who's actually currently the Chief Executive of the Health Education England. And it says that Professor Ian Cumming, at the time of the inquiry's hearings, thought it was an omission that the Constitution did not make specific reference to the protection that should be afforded to whistleblowers. So we actually have a Chief Executive of HEE, at the time of the Francis report, saying that we need to give more protection to whistleblowers, and now Health Education England doesn't seem to be taking quite the same view. Is that...
Well, he obviously forgot that when he instructed a barrister to claim that he had no substantial influence over junior doctors, his organisation. I mean, that's really important that I emphasise that. So, Health Education England, at my employment tribunal, paid a barrister to essentially come and argue, convince a judge that the organisation that recruits a doctor has ultimate power over their career progression, imposes all sorts of ARCP requirements on them, actually has a trivial influence on their career and employment. And they convinced an employment judge that that was the case, and that's what broke whistleblowing law. And has been preventing my case being heard for 2.5 years.
So I'm obviously, your case is ongoing, you're appealing it at the moment. I'm not going to say that a judge made a mistake, it's not my place to say that. But in terms of looking at the effects of that judgment, it seems to be that an organisation that has absolute power over the career of a junior doctor can do whatever it likes to a whistleblowing doctor and get away with it. What do you think is the likely effect of that for patient care?
Well, I think Sir Robert Francis's report will tell you where that approach leads, and it's not a very nice place, is it? But I think it isn't just whistleblowing. It's the fact that you have this essentially de facto employer who really, to all intents and purposes, has ultimate employment control and ultimate career control, and it's essentially a monopoly in England for a career in medicine. And they are able to get out of employment law, whistleblowing law, and maybe even bits of the Equality Act.
So I just want, so for instance, in your case, it's not like anyone else sort of just losing their job, is it? You can't work, you've lost your training throughout England. You can't go and work in another hospital in Manchester or Liverpool, is because you've lost your career effectively. Is that not the case?
Well, it's the case that I've lost my career progression, but I mean, very, very importantly, I've lost my employment path. You know, I had a run-through training contract which would have provided me run-through training employment till I was a consultant. So I might have lost a lot of things, but I say in court that I've lost my employment, and Health Education England say we have nothing to do with employment.
So, okay. Now, just moving on a little bit, because this is actually, this organisation, Health Education England, is very interesting to me. So this organisation that said it's a training organisation has no real impact on your work, your employment, and therefore is not responsible in any way to an employment tribunal. I've heard that recently it's written a letter to all the chief executives of all the NHS trusts in the country saying that it will withdraw funding for trainees if those trusts do not impose the new contract. So in a way it's saying when it comes to you, it seems to be not nothing to do with your employment, but it seems to have a huge impact on the employment of every doctor in this country. Is that the case, or am I missing something? Or
well, I mean, it's certainly evidence of substantial influence, I would have thought, over employment. But it is in the context of the junior doctor dispute. It's essentially, it looks like, on the basis of what's written in that letter, that HEE could be a very good way of imposing a contract by proxy. It's hard to see it any other way when you see a letter like the one that you refer to.
So I mean, we all know recently in the famous Justice for Health case, it's that the Health Secretary denied that he was trying to impose the contract at all. And now we see, it looks like perhaps, as you said, Health Education England is imposing something by proxy. Who is Health Education responsible to? Who's the person who actually appoints everyone in Health Education England?
Well, I mean, I'm in litigation with HEE, so I'm going to be careful what I say.
Okay. Well, okay.
I think the point here, Moosa, is that this is about protecting junior doctors' employment. They have ultimate control over junior doctors' employment, and they can get out of going to an employment tribunal. I don't think it's more complicated than that. I'm sure it is, but I think for the basis of what I want to say to junior doctors, it's not.
Okay. Well, just in summary, I'd just like to say to viewers that Chris Day obviously is bound from saying certain things, but we have an organisation that controls our careers, is basically denying any liability under whistleblowing legislation to an employment tribunal, and at the same time seems to be exerting a lot of influence on NHS trusts, on every doctor in this, to have this contract imposed on every doctor in this country. And in fact, this organisation, even though the Health Secretary is denying that he's imposing this contract, this organisation is directly responsible to the Health Secretary according to the Care Act, and is appointed by the Health Secretary. That's very interesting for me, and I hope it's interesting for you.